As of this taping, which is 2 o'clock Pacific time on June the 14th, we are waiting on the verdict in the criminal trial against Bill Cosby. He's accused of drugging and then sexually assaulting Andrea Constand in January of 2004. Of course, Constand is just one of 50 women who have, more than 50 women now, who have accused Bill Cosby of drugging and in some method or by some manner sexually assaulting them between the mid-60s and 2008 when the last allegation, or the allegation, the most recent conduct occurred. One incident involved an alleged incident involving a 15-year-old girl. So this is, some pretty tawdry stuff. The vast majority of these alleged crimes were not reported to police for years or decades after they occurred. Most have been taken care of by virtue of the statute of limitations. Cosby has also allegedly or reportedly resolved many of the cases, civil cases potentially against him through settlements that have been quietly made and not made public until recently. Cosby, in deposition testimony and constant civil trial, which has since settled, admitted that he has, in fact, provided drugs to women, including Andrea Constand, and that he had sex with them, but he has repeatedly claimed that it was all consensual. The drug use and the sex was all consensual. Since those allegations really began to surface in 2014, and then far more recently as the criminal charges have been levied against him, Derek and I have been bombarded with questions, dozens of questions concerning the case, concerning the various factors that go into the decision to prosecute him. There was a prior settlement agreement with Andrea Constand, which a lot of people have asked about. How is the prosecution now allowed to bring a case that has been settled, and the confidentiality agreement in place regarding Constand?
And it's D-Day today. We haven't avoided them, but it just seems like this Cosby stuff was so... We were inundated. There was a period here where we were just fielding lawsuit after lawsuit. Janice Dickinson came out, and we didn't really know how to just tackle this issue, so we decided to do it all at once.
We waited as long as we could,
episode.
And now as we're waiting for the verdict to come down, literally any moment we could be interrupted by it, and we'll certainly bring that to you if it comes out. This is the time is now ripe. The time is nigh.
The reckoning is here. Yes,
the reckoning is here. The evidence is in. All that remains is the jury's determination of whether Bill Cosby will spend what is very likely the rest of his life in prison for the alleged sexual assault and drugging and raping of Andrea Constand. I'm Jason Beckerman.
And I'm Derek Kaufman.
And this is Behind the Bar. So producer Parker and we went through a valiant effort to put together these questions into various buckets, and I think the first bucket, Derek, involves the fact that there have been over 50 women who have come forward, again alleging accusations dating back as early, alleging incidents dating back as early as 1960. And they've all come forward in recent years, but why this is the first and only case that has reached the point of an actual criminal charge and a trial.
Yeah, it's an interesting question, and we get a lot of it. So this case, the timeline's very, very important for this one. So the date of the incident was January 15th, 2004. Andrea Constand's working at Temple. She says she has this encounter with Bill Cosby where he gives her some Benadryl pills and then has what she claims is non-consensual sexual
really
contact.
Quick, just to be fair to the facts, she went to a private location with him and was prepared to engage in some sort of physical intimacy with him, it appears. He provided her with these blue pills. She says that she asked what they were, and he told her they were just herbals and that they would make her feel good and relax, and that's something she wanted, and she took the pills.
Right, but she then gave testimony that she felt powerless at some point and then comes to and feels the sexual contact at that point. Now, the Pennsylvania, so he was charged with aggravated indecent assault, which is just Pennsylvania's version of a sexual assault crime, and their statute of limitations is 12 years for those types of sexual assault claims. So we have January 2004. He's charged in December 2015. It's actually 2.5 weeks before the expiration of the statute of limitations.
Right.
So it was really just in time.
Right, and we'll get to why the long wait in just a second, which I know is an issue that Derek knows a lot about. But 12 years is a long time for a statute of limitations, and it's an exception to the general rule of 5 to 7 years for this type of a crime. So all of these other allegations that have come out in all these other states and others in Pennsylvania as well, because he lived there for a long time, obviously largely affiliated with Temple University in Pennsylvania. And so a lot of charges have come out, but they've been older than that in Pennsylvania or in other states. They just have not been within those state statutes of limitations, which are much shorter.
That's exactly right. So 34 states overall have statutes of limitations, somewhere between 3 and 30 years for sexual assault type crimes. And there's a good reason for these, right, Jason? Like, one, you don't want defendants and people who are accused of these crimes to live with that burden of a possible shoe dropping on them at any point in time. There has to be some some closure and finality so that you can move on with your life. The other reason is just, frankly, memories fade and evidence deteriorates over time. So the longer you wait to try these cases, people are going to forget what happened. In sexual assault cases, you have a lot of DNA evidence that's going to erode over time. So that's the second big reason. And the third is you really want to encourage people who are victims of these crimes to seek justice swiftly.
Yeah.
Yeah.
I want to go back to the deterioration of evidence point that you brought out, because that was really big in the decision by the district attorney who was in power back when Andrea Constand first came forward in the mid-2000s. He gave an interview when he was trying to justify his lack of prosecution of Bill Cosby, and what he said was it took Andrea Constand a full year to come forward. And we hear this from police and DAs all the time. It's decried by victim support groups and victim advocates as being sort of an excuse not to bring a man up on rape charges. But it is more difficult. And the district attorney made the point there was no forensic evidence. Because she had waited a year, there was no way to test her theories based on what was in her bloodstream, the drugs that were in her bloodstream, the physical assault, any physical damage she may have suffered as a result of the crime. These things could have been detected. And he said it made it much more difficult to prove the crime. And I know we'll talk about this in a second, but the next district attorney comes in and actually wins election based on the idea that he's going to actually prosecute Bill Cosby. And he says these things shouldn't have deterred us at all 10 years ago from bringing the crime. We can still prosecute and we can still win this case, and we'll talk about that also, whether that's likely or not.
Yep.
But this deterioration of evidence point really is the real reason, I think, behind a statute of limitations claim. In order to effectively prosecute someone most of the time, you need for that person to be able to, you need the evidence there, you need witnesses' recollections to be fresh, or they can really be torn apart on the stand. Something that happened 10, 12, 14 years ago, even our best of our recollections are hazy. We misremember things. We allow other facts to come in and conflate, we conflate our memories. And so, it really is. I think this deterioration of evidence point is really the most important issue.
I think that's exactly right.
So let's go to this prosecution point, because it's another thing that people have brought up, and it was really a big deal about a year ago when there were motions being filed to exclude this case. Cosby was trying to get this case dismissed, and one of the things he said was, look, I had a deal with this prosecutor, the district attorney of Montgomery County 10 years ago, that if I gave a civil trial in the Andrea Constand case, a deposition, if I stood for a deposition in the civil trial of Andrea Constand, I would not be prosecuted based on the testimony I gave there.
Yeah, and it sounds like he actually did have a deal with the prosecutor at the time. So Bruce Castor was the district attorney who gave this deal to Cosby. He said, look, as an inducement that we get this all out in the open and so that you can testify openly about what actually went down with Andrea Constand, I'll promise not to bring criminal charges against you so that we can actually move your civil case forward with your deposition. The problem with that is prosecutors are elected. And Bruce Castor is an elected official. As the accounts accumulated,
the 50 women now come forward who back up her story.
That decision in 2004 starts to look a lot worse as 50 other women come forward. So now Bruce Castor is under a lot of pressure. So he admits to making the deal. The deal was oral, unfortunately, for Bill Cosby. But Bill Castor, to his credit, said, I made that deal. I made that deal. But he was running against someone named Kevin Steele, who was the prosecutor waiting in the wing.
And this is 10 years later, right?
10 years later from the incident. Kevin Steele says, you know what? He runs on a platform. He feels the pulse of America turning against Bill Cosby. And he says, you know what I'll do? I got the case that I can actually bring him to justice. Our statute of limitations is 12 years long. I got 2.5 weeks. Elect me, and Bill Cosby will stand trial for this offense.
And I don't think, and we talked about this 2 years ago or a year ago when it was that this election happened, and we made the point that I don't think we've ever seen an election come down to a single issue like this one, and that was, I want to go ahead and prosecute Bill Cosby for the crimes that he committed back in 2004, and Bruce Castor says that he will not prosecute Bill Cosby for these crimes. And Kevin Steele won the election based upon that promise to prosecute Bill Cosby, and here we are.
And putting aside your personal feelings about Bill Cosby, I'm not a big fan anymore. All of these allegations have shook my faith in him. I can't watch his show with the same.
And you and I believe that he did these things. By the way,
I do. Frankly, I believe maybe not all of them, but I believe a large portion of them. There is some guilt on his part. I feel like this is a miscarriage of justice. I do feel like you should be able to have confidence in your elected officials at the time. If Bruce Castor made this promise, even if it's not reduced to writing, and it actually did induce Cosby to give an open deposition in the Andrea Constand trial, I believe that the next prosecutor should have to live up to that agreement.
And not only that, the next prosecutor is using this very deposition testimony, the transcript from the deposition, to prosecute him. So he's getting, not only is he not getting the benefit of the bargain is actually now being used against him.
It's a whipsaw. Yeah, he got screwed by this.
He really did get screwed. It's hard to shed too many tears for Bill Cosby, and we're not doing that. Bill Cosby is a bad, awful man. But our system of justice is what it is, and we know that guilty people go free all the time because we believe in the system.
Yep.
And here, the system screwed him, but boo-hoo for Bill Cosby.
Yeah, here's where we are. And, you know, he actually didn't testify, but if you remember during the trial, they read portions of his transcript, which he did, to his credit, testify openly, and I believe he believed he was being honest in that testimony, and it sounds pretty graphic.
Yeah, no, he gave detailed testimony about providing 3 blue pills to Andrea Constand, which I believe were Benadryl.
Right. This is a married man, too, testifying about his infidelities.
Right, exactly right. In testimony that he believed would be completely confidential, and let's get into that now. So during again, Andrea Constand brings a civil case against Bill Cosby back in the mid-2000s. He gives a deposition transcript, deposition testimony that's memorialized in a transcript. Subsequently, he and Andrea Constand reach a settlement agreement. He pays her an undisclosed amount of money, in exchange for which the case will be settled and all of the allegations and the settlement will remain confidential forever and ever. Mm-hmm. Here we are in 2017. The case has been brought. The deposition transcript has now been outed. Everybody knows what it says. It's out there on the internet if you guys want to see it. And Andrea Constand is speaking openly about the allegations against him, notwithstanding the confidentiality agreement.
Yeah, he's lost every benefit that he's had in terms of deals that he's struck with people. He probably is the most distrustful person there is at this point because the Andrea Constand settlement, I mean, it's a key part of settlements that you have them remain confidential. You also, in a settlement, typically don't admit guilt.
Right.
You just say, look, there's a lot of things that have gone on here. I'm not admitting one way or another, but to make this go away so we stop paying lawyers, let's settle. Right. And he lost entirely the benefit of non-prosecution and the confidentiality.
At the beginning of the criminal prosecution, Bill Cosby brought motions to suppress the deposition transcript and to enforce the confidentiality agreement, saying she cannot testify against me. We have a confidentiality. At the very least, she can't participate in the prosecution. She can't advise them. You know, if she's subpoenaed, I suppose she can testify, but she can't work with them to set up their case, which basically sort of kills the prosecution's case. They can't prep the witness. You don't know what she's going to say. But the judge took it under advisement, then rules against Cosby, discloses the not just the deposition transcript, the settlement agreement itself is now disclosed. The judge says basically, when you're accused of this kind of crime and you've taken advantage of the laws for this long, I don't care what the confidentiality agreement says. I don't care what the settlement agreement says. I'm going to allow this deposition transcript to come out. He made a point that Bill Cosby has held himself up as a person of great moral character to the press, and the public has a right to see that he is not, in fact, this person of great moral character. It really is.
It's troubling
the height
to me.
of activist judgeship. I can't believe this happened. I mean, here we are, and it looks like, you know, looks like a guilty man is on trial for his life, and we should all applaud that. But goodness, the price that we paid.
And, you know, we talk a lot about celebrity justice. It's a term that gets thrown around here as usually referring to getting benefit from being a celebrity. Maybe the jury would never convict a celebrity and things like that. But this is the darker side of celebrity justice. This was a judge who made a name for himself by saying, I'm going to send a message about Bill Cosby by releasing this. And really, for a Bill Cosby, there's no adequate remedy. Once that's released, even if it's an appealable order, the cat's out of the bag. He is lost regardless. There's no monetary compensation you can give to Bill Cosby once this deposition transcript's out there in the open. So I personally think it's a miscarriage of justice, regardless of what you think about Bill Cosby and his character.
You have a judge who is politically motivated. You have a DA who, by his own admission,
this is a perfect storm of bad for Bill Cosby.
Yeah, it's a perfect storm of bad for Bill Cosby. Once again, not easy to feel bad for Bill Cosby, but the system didn't necessarily work here. So Derek, we're awaiting the verdict in the Bill Cosby criminal prosecution. How do you see this playing out? What's your prediction for whether or not this jury that is currently deliberating is going to return a verdict of guilt or innocence?
You know, I think the longer we wait, we're on day 2.5 now.
Yeah.
Is that where we are? I think that tends to weigh in favor of acquittal. And, you know, I think the longer they deliberate, you have someone in there. if at the close of the prosecution's case, everyone was gung-ho wanting to convict him, you would think that would be a snap judgment by all 12 jurors. They got 7 men, 5 women in there, and they say, this guy did it, let's go on with it. What's happening, though, is they're asking a lot of questions. And as they ask questions, they're really digging into things and teasing apart and looking to see whether the prosecution has met its burden beyond a reasonable doubt. I think the longer they deliberate tends to push in favor of acquittal.
There are also a few factual elements that are difficult for the prosecution to overcome in this case. I think the first of those difficult elements is the 1-year time period between when the alleged assault occurred and when Andrea Constant went to police. And we talked about this earlier. And again, it's difficult to touch upon these issues without seeming insensitive to her plight, and we're certainly not. But nevertheless, in trying to prove a case beyond a reasonable doubt to a jury of one's peers, you have to establish why it is. You have to show why it is she waited a year. And there are good reasons for that. Victims of sexual assault do this quite frequently. It's hard to come forward, especially against someone who's as famous and as well-known and well-beloved as Bill Cosby is. It's hard to come forward. You are going to be dragged through the mud, and Andrea Constant has, and your life is going to be turned upside down as hers has. And so it's difficult to come forward. But nevertheless, during that year period, evidence did degrade. There are no toxicology reports based on her blood. There's no rape kit that was ever performed in this case. These are difficult hurdles for the prosecution to overcome. Also, in addition to that, after the alleged assault occurred, in the 1 year between the alleged assault and the actual and when she actually went to police and filed a police report, they had a number of communications with one another.
That's right. Apparently, there's been some reports that she contacted him 53 times. So after you have an assault of any nature, and the way she described it was heartfelt. I do believe she had some sincerity. To contact someone 53 times, it doesn't evince someone who is scared of this person. It evinces that there may have been a long-standing relationship of some sort.
And I just want to be clear: the 53 times were not, sort of demanding justice for him. They had some sort of a relationship, not a physical, intimate relationship. We don't know about that, but they had some sort of communication and open dialogue between them for the full year afterwards. Again, there are plenty of ways to explain that consistent with the fact that he raped her.
Sure.
But nevertheless, you can see a defense counsel making some hay
It's going to bubble
that.
up some doubt. And because the standard is so favorable to defendants, you could see some jurors possibly reading that. The other question we get a lot is, Bill Cosby didn't testify. He didn't take the stand live in court. But I'm not sure that many jurors are going to hold that against him. And the reason I don't think so in this particular case is because his deposition transcript was read.
Yeah.
So in a sense, Bill Cosby has testified in this case. I think a lot of cases where the defendant remains silent, there's an inference of guilt that they don't want to speak because they're worried about they'll incriminate themselves. Bill Cosby has been open and candid, at least in the deposition, so it might have been redundant. It would have exposed him to cross-examination of the prosecutor. I think it was a wise decision.
You very rarely see criminal defendants, at least blue-collar criminal defendants, as Bill Cosby is in this case, take the stand and defend themselves. Obviously, we have a Fifth Amendment right against self-incrimination. It's very important to our system of justice. Somebody they can't be compelled to get up and testify if they don't want to be in a criminal case. And there's good reasons for that. We always talk about what the British did to the American colonies back in the day, and one of the things was they would drag people up there and force them to testify, and it was bad scene. So we can't compel them. And judges, and I worked for the district attorney's office here in LA for a little while, and judges go to great lengths to assure the jury that just because somebody is deciding not to testify in their own defense does not in any way indicate that they're guilty. And by the way, that's true as a matter of fact and principle. Mm-hmm. There are lots of people who are accused of crimes they didn't commit, and those people don't necessarily take the stands in their own defense because you don't want to subject yourself to cross-examination. It is unpleasant to be cross-examined and have your words teased apart and have lawyers twist them, and you're up against lawyers who are well trained in doing this kind of thing, and they can make totally innocuous facts seem uninnocuous, seem I don't know what's the opposite of innocuous, meaningful.
Yeah.
And so you have to deal with that, and you have to make those assessments. The only time you will ever see it is when you have your client is extremely intelligent, and you feel that he or she can withstand whatever they're going to get from the prosecution. But even then, it's not a good decision to make.
It's a risky proposition.
Again, we're anticipating that this jury is going to come back with their verdict at any moment now. Certainly in the next 24 hours. I'd be shocked if it went longer than that. And I think we're going to want to pick up on this discussion once we have the verdict, and we can talk about the rationale for it, assuming that we get something from the jurors. They're always, talked to later. The media will try and get their attention and try and get them to speak to cameras. So happy to talk about that. And also, feel free to write in your questions, and we'll address them as best we can.
What's that?
I believe that's
I
mail
never
time.
asked that question. You get to say mail time.
It's mail time. Remember to write in your questions and comments to behindthebar@tmz.com. First one up is from Loretta. Why doesn't double jeopardy apply to hung juries or mistrials?
People have been listening closely. They remember our double jeopardy episode. So a mistrial, a hung jury, is a mistrial. It's not a final judgment of acquittal or guilt. So cases have developed over time that double jeopardy doesn't attach. They can retry you as many times as possible. It's not the same. It isn't unfortunate. It does go to the star chamber aspect of our justice system, but you got to make some compromises.
You do. I mean, in the Constitution, it shows the limitations of what the founding fathers and then the subsequent amendments to the Constitution it shows the limitations on that. In this case, in the Bill of Rights, is the protection against double jeopardy, and our founding fathers did not write an exhaustive list of what constitutes double jeopardy, what doesn't. Instead, you've had two and a quarter centuries of case law that have come down since interpreting these provisions, and what the courts have interpreted this to mean is that the initial matter must go through must be complete, and that completion means not just a trial, it means a judgment or a verdict. And it also means the right to an appeal, as we saw in the Aaron Hernandez case. It's not truly closed until you go through the appellate process. Only then does double jeopardy apply.
That's right.
All right, next one up is from Emily. I know the Maryland and D.C. Attorney General just announced their own lawsuits against President Trump for flagrantly violating the Constitution and its emoluments clause.
We didn't even see that, Parker, and we knew what it was. Go ahead.
What are possible outcomes of this case? Can a lawsuit by a citizen or a state result in the removal of a president, or is it impeachment the only avenue?
I want to see if Derek, in 20 seconds, no, I'll give you 25 seconds, can explain the emoluments clause in the Constitution.
Oh, boy. I want to see if you can do it in 20 seconds. I cede the floor to you. The emoluments clause basically says that people in elected office and high elected office, especially the president, can't benefit in a financial way from being president. They can't take gifts, and emoluments is an old term for gifts from foreign dignitaries while they're in office.
Well done.
How does that work?
So well done. So we've had this issue where President Trump is allegedly, and I think pretty apparently, right, benefiting financially from his position in office.
Owns a lot of hotels. Foreign dignitaries come into town. They feel if they stay at his hotel, they might curry favor.
And part of it's not his fault, right? I mean, he is a businessman, and he has got a name all over these buildings. He doesn't want to take them off. He's created trust.
Well, it's his fault that he hasn't divested himself from those businesses.
Right. And therein lies the allegation that he hasn't divested himself. He's still profiting from these things. But, a bunch of individuals have tried to bring these lawsuits against him to say, hey, you're violating the emoluments clause. You've got to, the punishment would be you have to actually divest yourself. The court will enforce the divestment.
Right.
But you have this problem with standing. Who's allowed to bring these kind of lawsuits? Who's actually being injured by it? And so now the state of Maryland, where Donald Trump has property, is coming forward and saying, we're an injured party. And I don't know exactly what their logic is, but they're trying to establish standing and actually get this case forward. And Derek, why do these cases, why do these plaintiffs so desperately want the case to survive? It's not because they care about divesting his property.
No.
It's because they can actually, once they get a case going forward, they can issue discovery requests. First and foremost,
those tax
let
records.
me see your tax records. And if a case is allowed to go forward, if it survives motion to dismiss, they will request tax records, because those tax records are the only way to fully disclose what properties he has and what he's profiting from.
And don't you think one of these cases has to survive standing? I mean, if there is an emoluments violation, someone has to have standing to bring that case. I've heard a lot of people say, like, what is the injury to Maryland? What's the injury to this nonprofit group that brought it? Someone surely has been injured in a way that would enable them to right this wrong.
Yeah, maybe. I mean, one would think that you can't have you can't have a
wrong without a remedy.
You can't have. Well said. You can't have a wrong without a remedy.
All right, last one is from Daniel. What are your guys' most memorable law school moments?
I had a great constitutional law professor, my favorite professor I had my entire 3 years. He was my first, civil procedure professor, boring class, but he was a great professor. But he was also really nerdy. And so, but at the end, he really cared about teaching. At the end of the last class of the first year, everybody's finally through your 1L, your first year. Everybody's, thank God, finals over. We go back in for the last class where maybe it was before finals, but we go in for the last class, and he gives a really rousing speech about what it is to be a lawyer, why it's so important, and why we have an obligation to uphold the dignity of this profession. And he was a terrific professor. So he finishes this diatribe, and everybody stands up and gives him a standing O. He literally tips his cap to us and says, "It's been a pleasure, young ladies and gentlemen. Good luck." And he goes to walk out, and it's one of those fire doors. It's got the large sort of springy wood metal handles on it. and he goes and he presses hard as he can into a completely locked door, and he face plants into the door. And he just had to then, without like turning to us, because I'm sure his nose was bloody, has to slide to the other door. He has to slide to the other door and push through it. It was really funny.
Moment destroyed.
Yeah. Shout out to Lawrence Solom. Great professor.
I guess I would have to say, early in my law school career, you take civil procedure. It's one of your basic classes that you have to take. My professor was Harold Coe, and everyone is very earnest. He's a top-flight international law scholar, and he does this presentation where he shows us movies for 2 classes where they're all movies that we love, and he taught us civil procedure by showing the flaws in civil procedure through film, and I thought it was great because good. I loved the movie My Cousin Vinny. I watch it through an entirely new lens now because that is not how law is practiced.
Just to bring these two together, the professor I mentioned, Lawrence Solom, actually after he left my law school Loyola here in LA, actually took a step down and went to Harvard and teaches there now.
So, lovely.
But you know, everybody's got to do something in retirement.
All right, guys.
All right, thanks very much. See you next week.
Thanks.
Thanks for watching. If you want more nerdy deep dives into the legal side of celebrity news, hit our subscribe button right here.
And check out our previous episode over here.